I thought they must really want to overturn it. And now I'm not sure.
Good afternoon. We could bring the room to order, please. We're going to try and get started if we could, please. You can hear me in the back. Welcome back, and please, we're going to try and get started here, even though we're going to continue lunch service, and please continue eating your lunches and then have dessert. I'm Dean Reuter, still the Vice President and General Counsel of the Federalist Society. That wasn't supposed to be a joke, Michael. Thank you, yeah. Thank you. Welcome to our luncheon panel, Revisiting Judicial Deference. I'm going to be very brief. My only job here is to introduce our moderator and thank in advance our moderator and our panel for continuing what I think has been so far a terrific day looking at the administrative state. We're very pleased to welcome Sarah Harris. She's a partner at Williams & Connolly and runs their Supreme Court and appellate practice. Before joining that firm, she was a Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel, fairly recently, I might add. And before that, she clerked for Justice Clarence Thomas. So with that, I'll turn things over to Sarah Harris.
Thanks, everyone. It is a true delight to introduce such a distinguished panel today to discuss judicial deference. Our first panelist is John Eastman, who is the Henry Salvatori Professor of Law and Community Service and the former Dean at Chapman University's Fowler School of Law. He also clerked for Justice Clarence Thomas and is a senior fellow at the Claremont Institute, as well as the founding director of the Institute's Center for Constitutional Jurisprudence. Next is Roman Martinez, who is a partner in the Supreme Court and appellate practice at Latham & Watkins. Earlier in Roman's career, he served as an assistant to the Solicitor General at the Department of Justice, where he argued a number of cases before the United States Supreme Court. And before that, he clerked for Chief Justice Roberts on the Supreme Court and then Judge Kavanaugh on the DC Circuit. We also welcome David Vladeck, who is the A.B. Chettle Jr. Professor of Law at Georgetown University's School of Law. He served as the director of the Bureau of Consumer Protection at the FTC during the Obama administration. Prior to joining the Georgetown faculty, he served as a staff attorney and then director of Public Citizen Litigation Group. And finally, we welcome Adam White, who is a research fellow at Stanford University's Hoover Institution. He's also an assistant professor at George Mason University's Antonin Scalia Law School, where he directs the C. Boyden Gray Center for the Study of the Administrative State. So this should be a lot of fun, and I would like to kick off our panel with some panel participation questions, because I think it will help show what a diverse group of viewpoints we have here on judicial deference. So let's kick it off. Who on this panel thinks that the Auer doctrine, the doctrine holding that courts must give controlling deference to administrative agencies' interpretations of their own ambiguous regulations, is unlawful? Raise your hand.
Is unlawful?
Unlawful, not lawful. All right, 2 of 4. Who thinks that the Auer doctrine is lawful, but a bad idea for policy reasons? All right. That leaves David as our Auer defender. Let's do the same thing for the Chevron doctrine, which, as we know, is the doctrine holding that courts must give controlling deference to an agency's reasonable interpretation of an ambiguous statute that Congress tasked the agency with administering, at least so long as the agency advances that interpretation in a sufficiently formal form. Who on this panel thinks Chevron is unlawful, not lawful? 2 of 4. Who thinks that Chevron is lawful, but a bad idea for policy reasons? Okay, no one. And that leaves both Adam and David to sort of debate how far they like Chevron as a policy matter and the legality of it. So I think, as this illustrates, we're going to have a fun discussion before us. Before we get into where judicial deference doctrines are headed, especially in light of pending litigation at the court, I think it would be nice to talk a little first about how we got here. Today, we sometimes hear talk about Chevron and Auer as if judicial deference to agencies on various legal and factual questions is the core fixture of administrative law. But let's probe that a little bit. John, how did the Supreme Court come to embrace these deference doctrines? And what do you think the pre-deference world, to the extent there was one, really looked like?
Well, and I think the SG's brief in the current case up at the court right now, Kisor, lays this out pretty well, the history of this. Seminole Rock is the precursor to Auer deference. But Seminole Rock really doesn't stand for the full-throated deference to agency interpretations of its own regulations that we've come to know as Auer deference. It was more of a side-glancing comment in the case. The real binding deference that we take Auer deference for, that's of more recent vintage. And Chevron deference is also of more recent vintage, as Chevron itself is. And I suspect what got us to Chevron deference is part of the anti-Warren court litany of criticisms from the Nixon administration, in particularly the Nixon administration administrative lawyers, one of whom most famously was Antonin Scalia, about the unelected judiciary effectively lawmaking from the bench. And the theory behind it was that if we put those deference doctrines in place, like Chevron Step 2, that we have an executive agency making those initial judgments, and they are at least nominally accountable to an elected official, the president, and that's an improvement over these policy or legislative judgments being made by unaccountable, unelected officials. Now, that was the theory, I suspect. It didn't work out that way in practice, because, the unelected bureaucracy is no more accountable to the president in many instances than the judges are. And so I think that we then see Scalia in particular, but others, after experience with those doctrines, starting to question the original theory underlying them.
Great, so let's jump into some questions about Auer deference and its future. In recent years, there has been a groundswell of criticism of Auer deference. For a while, it seemed like every term involved separate opinions and dissents from the denial of certiorari, in which various justices expressed growing discomfort with Auer deference. And now, Auer has sort of become the bridesmaid that turned into a bride this term. The court has finally granted a case called Kisor v. Wilke to reconsider Auer deference. Let's go around the table. The first question, what do we think the court should say about whether Auer deference is lawful? Should we start with John?
Sure. I mean, I think the court needs to put this genie back in the bottle. Look, you got to step back and look at this from basic separation of powers principles. Where is the power to legislate, to lawmake, assigned in our Constitution? And it's in Congress. And where is the power to interpret the law under our Constitution? It's under Article 3 in the courts. Our deference allows agencies to both lawmake and interpret, and then go ahead and execute. It combines all three powers of government in a single, unaccountable, unelected hand. And I think it's got to be repealed. And I think, Justice Thomas has been on this mission since 2001 in the American trucking case. He's gotten increasingly more vocal about the dangers of Auer deference to basic separation of powers principles. Justice Scalia, who authored that doctrine right before he passed away, said that he would overturn it as well. There's a story I'm told in the hallways of the court. Justice Scalia finally Thomas said to Scalia, we got to get rid of some of these deference doctrines. And Scalia said, yeah, they're awful. But you authored one of them, Nino. He said, yeah, I know, they're awful. We got to get rid of them. I don't know whether that's true or not. It's a good story anyway. But the commitment to separation of powers that Justice Scalia exhibited over his life, I think, finally came home to when he realized what Thomas had been talking about, the dangers to separation of powers that, in particular, the Auer deference doctrine represented.
Ramon, what do you think?
I think I generally agree. Let me just start, though, with a full disclosure, which is that I represent clients in the Kisor case. I represent a coalition of 9 veterans groups, and we have called for Auer deference to be overruled. But the good news is that I'm very lucky in that all my clients happen to be correct on every issue as a matter of law. I agree with John's point, general point on the separation of powers. You know, this maybe seems simplistic, but I tend to think that the role of the judiciary is to say what the law is. That's something that's vested in the Article III courts, both under the Constitution and I think in this particular case under the APA as well. In addition to that sort of separation of powers concern and the role of the courts and their exclusive authority to interpret decisively what the law is, I think there's a rule of law concern as well. And I am a product and proud exponent of the sort of original public meaning textualism approach to interpreting legal text. So I generally think that whether it's a regulation or a statute, the law should mean basically what it meant to the public at the time it was enacted. And that the goal of interpretation needs to be to do the best you can, very best you can to figure out what that is. And I think that the problem with some of the deference doctrines, including our deference, is that it tells courts that in certain circumstances you're not going to apply that. You're going to apply a second best interpretation or an interpretation that you think might not be the best, that might be wrong, in fact, because it's not the best. And that strikes me as a real significant challenge to the rule of law and to the idea that we should be governed by laws that are established either by Congress or by agencies exercising authorities, processes delegated to them, specified by Congress. So that's why I think ours should be overruled.
David?
Yeah, since I'm the only one who's going to give a full-throated defense of Auer, let me take a few minutes. First, there's nothing unconstitutional about delegation of power. And unless the court scales back the delegation doctrine, these constitutional arguments are just not going to fly. Second, Auer does not simply forfeit judicial control. Remember, Auer is a doctrine made by judges. It has not been imposed on the court by Congress. And it simply states a common sense understanding that courts will defer to an agency's reasonable interpretation of its own rules. Now, before you get to deference, the court must make a number of findings. One is the regulation ambiguous to begin with? If not, no deference. Is the agency's interpretation one within the interpretive choices the ambiguity affords? If the answer is no, no deference. Is the interpretation arbitrary or capricious? If no, no deference. Is the interpretation in conflict with prior interpretations? This is the reliance back to expectation point. If so, no deference. Is the interpretation inconsistent with the underlying regulation? You go on and on. There's a huge amount of judicial oversight of this process. It is not the automatic deference that it's been described, nor is the history really correct. So Auer deference is known by that name because Justice Scalia is a great writer. But the deference that Auer requires has been part of our jurisprudence long before the APA. It traces back to 1898, where the court said, and now I'm quoting, the interpretation given to regulations by the department charged with their execution and by the official that has that power, with the sanction of the president, to amend them is entitled to the greatest weight, and we see no reason in this case to cast doubt on the correctness. Our doctrine has been around for more than a century, and to overrule it would be enormously destabilizing. One more point. The idea that interpretive rules, which is what's at issue in Auer, are ways for agencies to assert power is just backwards. Interpretive rules are a one-way street. They limit agency power. They don't provide it. Interpretive rules, as opposed to legislative rules, bind agencies in ways that do not bind the public. At the FTC, I couldn't, as a matter of law, use a guidance document, an interpretive rule, to bring an enforcement action. It would not be evidence of wrongdoing to violate a guidance document. I would have to prove a violation of the underlying statute. But on the other hand, were I to bring an enforcement action that was inconsistent with an interpretive rule, the case would be thrown out for lack of fair notice. So interpretive rules undermine, in the long run, agencies' authority. So the idea that agencies have incentives to enact broad and ambiguous regulations because down the road, Auer might give them a way out, just doesn't make any sense. It's antithetical to the way any reasonable agency would act. Legislative rules give agencies power. Clear and specific legislative rules promote compliance and ensure efficient enforcement. That's the regulator's creed. And if you want evidence about this, just go look at the Administrative Conference's 2017 report, which did a thorough investigation of this issue and concluded that I am right. So the bottom line is, be careful what you wish for. Throwing Auer out will destabilize a system that has long been in place and undermine other deference doctrines that the court has carefully erected over the last century of administrative lawmaking.
Adam, what do you think?
I feel I'm now sitting next to the most conservative panelist in the room, the one who wants to disturb no settled expectations, retain all traditions, and change as little as possible. So here's my view of Auer, and it's part of my view of Chevron. Chevron and Auer are both doctrines that attempt to grapple with a very challenging question: what should the courts do in a place where laws are written vaguely? Right? What's the court's duty in applying vague laws? Now, this is the second best world, right? The first best world would be the lawmaker writes the law very precisely, and then it's very easy for the executive and the judicial to apply it. But that's not the world we live in, and it's maybe never the world we've lived in. Read Federalist 37, James Madison, explaining why all laws are to some extent or another vague, and how we should grapple with that. Even Federalist 78, which we always cite as the bedrock presumption that the duty of the court is to have neither force nor will, but merely judgment, right? Inspiring Marshall to say courts are going to say what the law is. Even Federalist 78 sketches out a pretty deferential standard of review in some circumstances. So for me, when I look at these two doctrines, Auer and Chevron, I ask myself, what creates the best incentives going forward for the person who's writing the law, the person who's executing the law, and the person who's interpreting the law? These are all practical doctrines for the reasons that Scalia put forth, I think, better than anybody in his Duke Law Journal article in 1989. And so I think we have to think about it in those pragmatic terms and learn from experience over time and recalibrate these doctrines over time. I don't think these doctrines, I disagree with my friend John, I don't think these doctrines are directly deducible from the Constitution or even from the APA. And so I think we need to recalibrate these things over time in light of experience. And where I come down on this is on Chevron, which we'll get to later. I've gone from being critical of Chevron to being anti-Chevron, and now I'm just admitting, okay, I'm pro-Chevron. Pro-Chevron, rightly understood. I guess mend it, don't end it. But with Auer, I do think it's time to get rid of it. I think it creates exactly the wrong incentives. I think that the instinct that Justice Scalia got from John Manning, this analogy to the separation of powers, is the right instinct. But I think in practical terms, Auer creates the wrong incentive. It enables or incentivizes the lawmaker, in this case the agency writing rules, to be lazy. I don't know that the problem is agencies are going to be tactical and scheme on how they can write a vague law and then exploit that later. Maybe that's a problem. I'm worried about the much more mundane issue of lawmakers not thinking hard enough and precisely enough when they're writing the law. And I think only by getting rid of our deference are we going to create the right incentive for the lawmaker, here the regulator, to be extra precise in writing the law in the first place.
All right, on behalf of the anti-Auer camp, John Eastman, I'll give you a very brief rebuttal because we've heard a lot in terms of, challenges to various legal
Yeah,
provisions.
so, I think we've got to confront how this really works in practice. And Gene Scher here at the front litigated the GG versus Gloucester County case. And the way this really works in practice is you've got a statute, Title IX, that prohibits gender discrimination. It's got an explicit exemption for private facilities. You got a regulation adopted roughly at the time of the statute that acknowledges that exception. And then you get in the Obama administration an undersecretary, acting deputy assistant to somebody who writes a guidance memo that says if you don't allow transgender kids into the bathroom of their choice rather than one of their biological sex, you're violating Title IX. And woe to any education facility in the country that didn't comply with that guidance memo, because this is going to be the basis of their loss of funding. And so the guidance memo, with no legal authority, in fact directly contrary to the legal authority, all of a sudden is driving the law. And so when I say they are making law in direct violation of the separation of powers, that's the way it works on the ground. And that we have to acknowledge, I think.
I think the next question for us to confront on this, we've raised sort of a lot of interesting questions about practical concerns, and David in particular has already talked a little bit about whether or not overruling Auer would have dramatic effects in really stare decisis considerations that the court should take into account. So let's go around and sort of talk, our panelists, starting with John, where we come down on what the court should say about how stare decisis affects the Auer analysis.
You know, I wrote an article a number of years ago on stare decisis called Conservatism's One-Way Ratchet Problem. If stare decisis is as it was originally designed, a doctrine of humility, that the courts are not going to lightly revisit considered judgments of its predecessors for stability reasons and everything else, that makes sense. But the notion that we would use stare decisis to lock in patently unconstitutional rulings just because they'd been said before or held before makes no sense from a constitutional perspective. It's like a referee at a football game where you got to have 2 feet inside the line for it to be a valid catch, and they call the game with one guy in the foot. Well, we don't look to that bad judgment for the future rulings. We look back at the original rule book. And a stare decisis that locks in unconstitutional rulings has to be thrown over, I think. Justice Thomas has been particularly vocal about that, and I think he's right about it.
So I think the stare decisis concern is the problem is very real. It's very significant. I think, you know, as a small c conservative, I think I'm generally very strongly in favor of stare decisis. I do think that if you agree with some of the points that John has been making and some of the points that I was making about the fundamental problem at a constitutional level between the deference doctrines and what the Constitution requires, I do think this is the kind of fundamental issue that the court would need to fix and that would overcome the traditional reluctance, at least with respect to Auer in particular, and would allow a court to, and should allow a court to go forward. I do think that there is a very significant practical problem with the fact that you have a lot of decisions out there for years that have applied Auer or a version of Auer. And so then the question arises, what do you do about those decisions? I think that if the Supreme Court wanted to overturn Auer, it could choose a couple of different options. You know, you could do something like somehow grandfather in all those decisions, which looks a little bit messy and ugly and impure, but at least solves the problem prospectively. I think you could acknowledge that those decisions have the stare decisis effect of those prior decisions applying Auer need to be analyzed in stare decisis terms, case by case, individually, one by one. And you know, typically courts will be much less reluctant to overturn a statutory holding or interpretation of a regulation. So maybe that's how you can kind of avoid the disruption of overturning Auer. But at the end of the day, I do think that if you conclude that the constitutional problem here is fundamental and is important, then I think that stare decisis probably should not be a barrier to overturning the doctrine.
So I don't disagree with John that unconstitutionality should not, stare decisis should not preserve an unconstitutional ruling. The problem that I have with the argument about separation of powers is that in order to get to the result that John and Roman advocate for, you have to have a revolution. Which are explicitly based, Chevron, Auer, these are explicitly delegation cases in order to reverse this case on those grounds. The other point is on, or principally to avoid what the government thinks are really serious dislocation issues. Away. Consequences of that would be quite severe. And the government's argument is, don't throw us into that briar patch.
So as Sarah mentioned, I run a program at Mason called the Gray Center for the Study of the Administrative State. One of the fun parts of my job is, since we incubate a lot of law review articles, I get to see sort of a lot of really interesting articles that are bubbling up right now before sort of the general public. It's great. It's like getting previews of all the best movies, except with law review articles. And we just, there's a really great article coming out by Randy Kozel of Notre Dame. He's thought deeply about this. He writes a lot on stare decisis. And he has a paper, it's available on our website, where he grapples with how to think about stare decisis in the context of deference doctrines. And here, I think I'm going to defer to him. I think he makes a very good argument that interpretive methodologies are not themselves the stuff of deference, right? Deference is better suited for real substantive rules and something less like an interpretive methodology. It would be great if someday the Supreme Court declared with precedential effect that originalism is the methodology by which we'll interpret the law. It probably can't do that, and I don't think it can lock in an approach like Chevron or Auer either. In this case, even setting that aside, it's harder for me to see what real damage stare decisis would protect against here. First of all, Auer deference, the whole point of it is uncertainty. The whole point of it is for agencies to be able to change from administration to administration, right? The point of it is uncertainty. And once you get rid of that, if agencies don't like how their rules might be interpreted by courts, well, there's an app for that. It's called notice and comment rulemaking. It's pretty easy. I've seen it done. And they should go back and sort of fix these things in the actual written law. I just don't see a whole lot of practical damage being done here that stare decisis needs to protect against.
Ramon, David mentioned some interesting points with respect to the Solicitor General's brief in Kisor and the institutional considerations it raised and the position the government took, which I think surprised a couple of people, maybe who were thinking the government might have come down a little harder on Auer deference. As I understand the brief, it adopts maybe 5 or 6 factors for potentially narrowing Auer. You have a unique perspective on this, I think, because you worked in the Solicitor General's office for several years. So can you sort of talk to us a little about what considerations you think might have played into the government's position and how there's a sort of balancing of perhaps institutional interests with obviously the aims of the administration?
Sure, and I should say up front, I have no inside information on this. I'm sure there are a number of people in this room who could provide a little bit more color and detail as to how this brief came together. I imagine that the Solicitor General's office, the Solicitor General in crafting this brief faced 2 very important sort of countervailing cross currents of argument and had to resolve them. On the one hand, I suspect there were a lot of people within the administration and maybe in this room who maybe share some of the skepticism towards Auer and probably were urging a more aggressive approach, maybe even calling for Auer to be overruled. On the other hand, the Solicitor General's office always has a deep and long-term commitment to the institutional litigating positions and interests of the executive branch generally, and there's a great reluctance to take positions that will be problematic for the government over the long run. And certainly in Auer, with a doctrine that directly benefits the government and that the SG's office has always defended. And so I think what the SG's office tried to do was sort of reconcile these competing impulses as best it could, and it came up with a brief that I think probably a lot of people, if they're looking for theoretical purity, are going to have trouble finding it in that brief. On the one hand, the brief is very critical of Auer and notes a lot of the problems that we've talked about. On the other hand, it defends Auer in certain ways, and it emphasizes strongly the stare decisis. And so it tries to put some limits on how Auer deference is properly invoked. It says that there needs to be a very rigorous sort of a step 1 inquiry where courts should apply traditional tools of construction and make sure that if they're going to defer, it can only be if there really is an ambiguity. And then a couple of other limits. The agency can't have changed positions. The agency position needs to have been given to the public with clear notice. The agency needs to be exercising its expertise, and the position needs to reflect the considered view of the agency. There are a lot of bells and whistles on this test. I think at the end of the day, it's probably unsatisfactory to a lot of people, but it's possible that it's going to be satisfactory to the people who matter most, which is the justices on the Supreme Court. I think it's possible that you could have a court that doesn't want to go all the way to overruling Auer, but does want to place some limits. And I think the SG's brief has done a commendable job of giving the court some options in ways that which it could make Auer a more modest doctrine that raises fewer of the concerns in practice of the concerns that we've raised today.
So that's a great seg to sort of wrapping up on Auer a bit. And what do you think, especially in light of the SG's brief, that the court's going to do in this case?
Well, I mean, the SG brief is a little bit hard to decipher. It's, what's the old adage? A horse made by a committee is a camel. This one's made of a committee of camels. I mean, it's hard to decipher the thing. What I fear we will get if the court adopts the SG's proposals, nuances, is an on-again, off-again use of Auer when we want it and not use of Auer when we don't want it, kind of like the ghoul of the lemon test. There when we want it and need it, but we get to ignore it when we don't want it. That's no test and it's no law. And I'm reminded of the source of all this, Justice Thomas's opinion in Perez versus Mortgage Bankers. He ties this back to the advent of the progressive movement and the whole notion that our agencies are better than us at figuring out policy decisions. We're going to people them with experts, and we therefore got to defer with them. I mean, it really does undercut the very notion of sovereignty of the people in governing ourselves. And at bottom, that's what's at stake. And it's no surprise that the forces inside the administration, in the agencies, want to keep their preferred place in our constitutional structure, this illegitimate one, of deference to their judgments about how we ought to govern our lives. And so that's really the heart of what's going on here. And I don't think the SG's brief offers a good line to solve that problem and rather than perpetuating it.
And Adam, what do you think will happen?
Well, so real quick on the SG brief, there's philosophers out there, we call them Straussians. They look for hidden meanings in complicated documents. I think the Straussian, the reading of the SG's brief is overrule our deference. I think the alternative that they've painted is so on its face unsatisfactory that I think the first part of the brief where they lay out the problems with Auer is the part I take literally, and the rest I take not even that seriously. I think what the court going to do, sometimes I think the court is going to, as we've indicated, come up with some sort of step 1 or step 0 threshold, put some limits around our deference. Of course, it's already subject to so many caveats. David went through them. It's another reason why I think stare decisis isn't as much of an issue here. I started to think maybe the court will just get rid of our deference, because we haven't really talked about what will replace it. Sometimes we assume it'll be de novo review. The alternative is Skidmore deference. And frankly, the Justice Department's brief, with all of its caveats and factors and so on, starts to look much more like the mushy Skidmore deference. That might be where we wind up, but I don't know.
Great, and I think we'll then move on to the second part of our fun deference discussion, which is Chevron deference.
Oh, well, wait a minute.
Oh, sorry, David.
Let me get my say in. I sort of agree with Adam, but I think the court is going to uphold some form of Chevron, of our deference based on the SG's brief. And I think there's good reason for that, because courts inevitably are going to give some deference to agency decisions so long as they're reasonable. And so it may, as Adam points out, sort of merge into some sort of muscular form of Skidmore deference or something else, but I don't think the court is ready to abandon this enterprise completely. And if you just look at the transcript, you know, there are a couple of justices who are plainly ready to get rid of Auer, but I don't think that's where the center of the court is.
Great. Well, with that, we are going to move along to Chevron deference, which I think is interesting to talk about which aspects of criticisms or defenses of Auer overlap with Chevron deference. So in recent years, we've seen, a lot of justices and judges calling for the narrowing of the circumstances where Chevron deference might apply, if not for eliminating the doctrine entirely. So you have Justice Thomas, Justice Kennedy, and then Judge Gorsuch seriously questioning whether Chevron is lawful, and then in his writings you have then Judge Kavanaugh suggesting that Chevron deference at a minimum should be reserved for cases that present true ambiguity, that there needs to be more rigor as courts sort of approach statutory construction, and that Chevron deference might also best be left to major rules involving major social or regulatory activities. So let me start with John. Do you think those jurists are right to be skeptical? I'm guessing the answer is yes. Do you think Chevron is consistent with the separation of powers? And if so, are there the same arguments as our deference, or do you think it's more, for instance, of a non-delegation problem?
It's more a function of non-delegation problem. But we've looked at Chevron as a transfer of lawmaking power from the legislature to the executive. And I think that's problematic enough. But what Justice Thomas has added to the mix is a transfer of the interpretive or judicial power from the judiciary to the executive. Here's what he says. The judicial power, as originally understood, requires the court to exercise its independent judgment in interpreting and expounding the laws. Chevron deference precludes judges from exercising that judgment, and thus rests from the courts the ultimate interpretive authority to say what the law is. See Marbury. Now, he's not alone in that. Let me read you another quote, and I'll see if you can guess who this one's from. Chevron suggests that administrators should decide the scope of their own authority. That notion flatly contradicts separation of powers principles that date back to Marbury versus Madison in Federalist 78. That's Cass Sunstein. Bill Eskridge. We join Chevron's critics from the perspective of the original constitutional design. Aggressive judicial review of agency rulemaking ameliorates the constitutional dilemma under which the modern administrative state has witnessed the shift of lawmaking power from Congress to the president. Bill Eskridge. So the criticisms of Chevron on constitutional terms run the ideological board, and I think it's very significant that you get at least, and there's a new revival of concerns about Chevron deference with this president in office coming from the left. Those were from the last Bush administration, Cass Sunstein and Eskridge. But I do think there are serious constitutional problems, both with legislative power being transferred and with judicial power being transferred to unelected bureaucrats and agencies.
So, sorry, Ramon?
Yeah, so on this question, I think that the arguments overlap, but let me just say sort of how I came to my current view on Chevron, because like some of the other panelists, maybe not David, I've evolved on this a bit myself. When I was in the Solicitor General's office, one of the things that we would have to do is review appeal recommendations and give a thumbs up or thumbs down to when agencies in the government wanted to appeal decisions. And we also, of course, would work on the briefs in the Supreme Court. And so a lot of the job was talking through with agencies what legal positions they wanted to take. And it struck me in a number of conversations with a bunch of different agencies that because of Chevron deference, the folks in the General Counsel's office who I were talking to, oftentimes you would have an honest discussion with them and you'd sort of talk through the statute and you'd push them on their interpretation. And they would basically agree that the best interpretation of the statute was not the one that they were picking, using the traditional tools of construction. So they would say things like, look, yeah, the text sort of leans that way, legislative history is sort of ambiguous, we got these canons, but we think it's close enough, because we think we've got a zone of ambiguity here, and therefore we're going to go with this other interpretation. And so even though within the agencies they thought the best sort of pure legal interpretation was interpretation A, for policy reasons, they thought they'd prefer to go with interpretation B, and Chevron gives them the green light to pick interpretation B. And I think if that case then comes to the court and the judge looks at it, and the judge agrees with everything I just said, A is the better interpretation, but B is reasonable, and that under Chevron, if the judge has to defer, you have a very strange result here, which is that the agency thinks that A is the better interpretation. The judge agrees that A is the better interpretation, and yet Chevron says, it doesn't matter, we have to go with B. That is a fundamental rule of law problem, it seems to me, and I think that honest agency general counsel, when you have these honest and candid discussions, I think they will admit to you that they are basically using authority to essentially depart from what they think the best interpretation is. I think that's a problem.
David?
Yeah, so let me build on this point. I think the conversations you had reflect my concern about Chevron. And I think this is why there's unhappiness within the court about Chevron, which is lower courts, by and large, have not really done the work they need to do on step one. They're very quick to find ambiguity. Government lawyers, that's their job these days, is to find an ambiguity and to use that as the basis for asking for Chevron deference. And so I do think there's a problem with the way Chevron has been applied, but I don't think there's a basic problem with the doctrine itself. But I do think, I think your conversation illustrates why there's frustration within the courts, not just the Supreme Court, about Chevron. And it has had, I think, a very profound effect on the way government lawyers defend agency action. On the other hand, I don't think there's any serious argument that Chevron is unconstitutional. It is a way of Congress delegating interpretive authority to agencies. Chevron, the doctrine of Chevron, again, was announced in a case, but the antecedents go back decades prior to Chevron. We've had a delegation doctrine that looks a lot like Chevron, delegation of interpretive authority to agencies, decades preceding Chevron. So the real question isn't, is it unconstitutional? It's a judge-made rule. The court can modify it as it sees fit, as long as it's not usurping authority that Congress has given to agencies. You know, one of the things that's really interesting in the Kisor argument is Justice Breyer talks about the sort of the withdrawal of these delegation doctrines as a power grab by the judiciary. And one of the tensions within the court is going to be, if you believe in the delegation doctrine and you believe that Congress has delegated interpretive authority to agencies, as it plainly has. I mean, agencies get the power to make rules that are law, the violation of which often can lead to serious penalties and at times a jail time. Unless you sort of winnow away on the delegation doctrine, the court's really going to have to struggle if it wants to simply eradicate some kind of deference to agency interpretation.
And Adam, we know that you are in the pro-Chevron camp. One thing we haven't heard as much about is sort of, what about the argument that Chevron is unlawful under the Administrative Procedures Act? And why do you think that's wrong?
Yeah, so the APA, and I knew this would come up, so I actually wrote it down. The APA, and I think this is maybe one of the strongest arguments against Chevron. I think people who see it my way really have to grapple seriously with this. The APA says that the reviewing court shall decide all relevant questions of law, interpret all constitutional provisions, and determine the meaning of or applicability of the terms of an agency action. And a lot of Chevron's critics right now interpret that as meaning the court must review this de novo. Maybe that's what it means. I don't think that's what it means. I think that the deference doctrines that predated the APA, ones that the framers of the APA in 46, some of them were familiar with, I think that they understood that even that provision did not necessarily require unflinching, undeferential de novo review. I think there's room in that provision for deferential review. I was struck by John's point a moment ago. John, were you quoting Cass Sunstein and Bill Eskridge in favor of your case? This is like the ultimate bootleggers and Baptists. I mean, if you don't want to agree with Cass Sunstein and Bill Eskridge, hi, my team is taking members. You can join us. But in what you sketched out before about Chevron, and the mention of the Kisor argument reminds me of this. When you watch the Kisor argument, you listen to the Kisor arguments, and you watch the debates about Chevron, you have this really interesting debate on the right and the left, progressives and libertarians and conservatives. Libertarians and conservatives really pushing for the judicial duty in interpreting the law and saying what it is, the progressive deference to expertise. And what I really think is falling out of all of this, and I think it's a real mistake, is the pro-democracy sort of Republican spirit that animated Scalia's version of deference. And I see that the deference debates are increasingly ones between the duty of judges and the expertise of agencies. And I think the best and most important defense, especially in our constitutional system, defense of these deference doctrines, is going unclaimed increasingly by both sides. And I think that's very dangerous.
Can I just take a quick sec to respond to David, because you've made the point a couple times, and I think it was very well put each time you made it about these doctrines coming from a place of delegation. And you said there's no question that Congress has delegated this authority. I think there's no question that Congress has delegated and can delegate sort of policy-making authority within bounds. But I think it's actually a very hard question, and it's not clear at all to me that Congress has delegated the authority to agencies to resolve ambiguities in the meaning of statutory terms. The court has talked about this as an implied delegation, but it's not clear why, in fact, it is implied. Even assuming that they could delegate that authority, it's not clear that they have. I mean, I think drafters of statutes and even regulations typically do not think they are being ambiguous when they're drafting language. And so, with respect to any particular provision, I think an ambiguity is accidental. I don't think that that particular ambiguity was intended to be resolved by an agency. And if that's true, then it seems like this sort of delegation theory is, as I think Justice Breyer and Justice Scalia have called it in different contexts, a legal fiction. And if you're going to have a doctrine like this that rests at bottom on a legal fiction, that seems to be, to me at least, to be a problem. So I would be interested in seeing, and maybe I haven't read deeply enough into this, a really sort of thorough defense somewhere of this presumption of delegation.
Let me respond very briefly. One point you missed, and this is fundamental, is there are lots of gaps that agencies need to fill. I don't think there's a serious argument that when Congress leaves that gap, it doesn't expect the agency to fill it. And a lot of the Chevron cases are gap-filling cases. Where there's an ambiguity, go to Capitol Hill. I mean, these ambiguities are not poor drafting. They're the inability often to find a sensible resolution of an issue, which they then kick down to the agency. And so, look, when I was at the FTC, we had to modernize a rule, the Children's Online Privacy Protection Rule. The question, what's a personal identifier? Now, who the hell knows? I mean, this was a highly technical question. It sounds, you know, if you just look at the language, you know, Justice Kavanaugh in Kisor basically makes the point, why is the agency any better at figuring that out than a district court judge? Well, because it turns out that it's a technologically laden problem where expertise is needed to resolve it. So I think there's a strong underlying support, theoretical and pragmatic, for the court's repeated insistence that these delegation doctrines, these doctrines about deference, are just a species of the delegation doctrine.
I agree with this point that the Chevron issue is tied to the non-delegation issue, but I think we're going to disagree on whether we ought to revive the non-delegation issue. Look, the basic principle is it's buried deep into the Constitution. Article 1, Section 1, Clause 1. Right? The lawmaking power is vested in Congress. And the court theoretically solved that problem about how to delegate to fill in the gaps. Congress has to make the basic legislative policy judgment where the details get filled in on how to comply with that policy judgment that was already made. That's the intelligibility principle. But when we approve as permissible delegations things like go forth and regulate the airwaves in the public interest, and all of these things that by no stretch of the imagination reach any notion of an intelligibility principle, we have allowed for that basic constitutional mandate to be ignored. And I think that's what's at issue. Can we put teeth back into an intelligibility principle in enforcing a non-delegation doctrine? Then maybe we can have something more with Chevron. But shy of that, Chevron just exacerbates the problem of delegating lawmaking power. And I'll give you one real key example from recent. There is no question that the Affordable Care Act would not have passed if the Stupak Democrats don't sign on to it after having their concerns about funding for abortion alleviated. Senator Mikulski had put into the bill in the Senate a provision on preventative care. And they said, well, it doesn't mean abortion. That's a lie by the pro-life folks put out there to get the Stupak Democrats off. Well, what happens when it gets over to the agency? They do exactly the thing that Congress said we weren't doing. And they knew they were going to do that over there. So they used this ambiguity to then write things that could not pass through the legislature. This is the fundamental lawmaking power problem that we get with these delegation doctrines, or the ignoring of the non-delegation doctrine.
So I think both John and David just raised something interesting, which is sort of differing views of when is there ambiguity, and is that sort of a fundamental aspect of what's going on in the with Chevron to begin with. So Adam and Ramon, if you don't mind both sort of talking about that, and if you, Adam in particular, if you see ways of limiting Chevron based on that principle, and Ramon, sort of how you see Justice Kavanaugh in particular and coming down on that.
Yeah, I keep mentioning Scalia. I work at the Scalia Law School, and I get a nickel every time I say his name. But I think he's right. Also, again, in his defense of Chevron, in his 1989 Duke Law Journal article, he stresses the right way to apply Chevron is with a rigorous step one, where you apply, an undeferential review in light of real originalist methodology. And doing that, he says, I'm going to dramatically reduce the field of ambiguous statutes. Not get rid of them altogether, because Scalia was practical and he understood that a lot of the statutes we're dealing with are extremely broad. I printed up an old essay he wrote in 81 where he pushes back against the Bill Bumpers Amendment to get rid of the early versions of deference. And he talks about transferring power to the courts to unilaterally ascribe meaning to what he called relatively meaningless laws. Not meaningless laws, but relatively meaningless laws. I think that's what we have to grapple with. The right way to do it is, first of all, Chevron step one, actually doing it seriously. I think experience has taught us we need a much more rigorous step zero, using the major questions doctrine to take the biggest policy judgments totally out of this conversation. But the most important thing we can do is do Chevron step one, but always understanding that, as James Madison pointed out, right there, he says in Federalist 37, he says all laws are to some extent vague because we are imperfect people, and we're dealing with complex subjects, and we conceive of them in our minds imperfectly, and we translate them to writing imperfectly, and then the reader interprets them imperfectly. There's always going to be some vagueness, some more than others. The Chevron framework allows us a way, imperfectly, to separate these categories, and I think you have to take step one seriously, and then also take step two seriously.
So I think a couple points on ambiguity. First of all, I completely agree, and maybe even we could get David on board with a robust step one.
That's what I said
So
10 minutes ago.
we
Yeah,
got
so we're all in
consensus.
favor.
Yeah, I thought I heard that.
Should stop the fatal now.
Maybe we should stop.
I changed my mind.
So I certainly agree with that. I think that in the cases where you do have ambiguity, though, two additional things. One, I think in the normal circumstance, if you don't have an agency in the picture, I don't think there's really any question that the ambiguity has to be resolved by the court. That's what courts are there to do, precisely because of the problems that are inherent with language and with legislating. And so it is sort of weird to say, oh, this is an insoluble problem. Who could we possibly get to interpret this statute? We must find some executive branch official to do it for us. Because this is like the wheelhouse of what courts do every day. The second point, though, on the Kavanaugh thing, I think Justice Kavanaugh has actually written some interesting things about this topic of how to define ambiguity. And his basic takeaway is that it's very hard for judges to agree on what counts as ambiguous and how much ambiguity you need in order to actually get to step two. And for Justice Kavanaugh in his writings, what that leads him to conclude is that the doctrine might sort of sound like something that everyone can agree to and everyone can sign up for and everyone can be applying. But in practice, in reality, judges are applying different tests because there's no really commensurable way or sort of uniform standard of applying the ambiguity threshold. And I think that's what leads him to think that in most cases, maybe not all, but most cases, judges, the right way to do this is for judges just to do what they normally do and apply the best interpretation. But I agree with him. I think it is a very hard sort of threshold question of how ambiguous is ambiguous, and how do judges talk about ambiguity and apply a standard approach.
Terrific. So I think we have about 15 minutes for questions, and there should be microphones, I think, midway through. So if folks could line up, we would love to hear from you, and then we'll thank our wonderful panelists.
While we're waiting for the first question, I want to take issue with something Ramon said earlier, which is that a lot of these ambiguities in the statutes are accidental. That may be true, but not all. In fact, some I think are deliberate, because what we've done is create a corrupt scheme that ambiguity in a statute creates the coin of the realm for re-election. Let me explain. I write an ambiguous environmental statute. I'm going to clean the water, right? And I don't have to take responsibility for any of the massive costs that would be imposed by the regulators. And I couldn't possibly get it voted through if that was the focus of the statute. So I passed this ambiguous statute, and then the regulators run crazy, and I blame all of the negative consequences of the regulation on those crazy regulators, while simultaneously lobbying behind the scenes to get the regulators to carve exemptions for my major donors. I mean, anybody that's in any agency in town knows this goes on over and over and over again. We used to call our chairman of our appropriations committee when I was at the Civil Rights Commission, the commissioner, because he had more power over the commission through these little backroom tactics than anything else. So I think the deliberateness of writing ambiguous statutes that they can then drive a truck through behind the scenes on the regulatory front, creating exemptions for their preferred, this is unbelievably bad for good government policy, and yet it goes on in almost every agency in town. And it's caused by these delegation doctrines, or the looseness of them, and the deference doctrine.
But the argument against Chevron can't just be sometimes congressmen do dumb or lazy or bad things, any more than the argument against, for Chevron is sometimes judges do dumb or lazy or bad things. I think we need to look across all of this, except that there's going to be good judges and bad ones, good administrations and bad ones, good members of Congress and bad ones. What's the best balance of power between the executive branch and the judicial branch when interpreting vague statutes that reaches the best outcomes over time and is most sort of closely tied, I think, to our Republican form of government? For me, I think it's Chevron, rightly understood.
All right, do we have any brave audience members? I think it looks like we're getting some. Yes?
Jonathan Adler, Case Western Reserve. One thing that hasn't come up a lot in this discussion before step one is step zero. And I'm wondering if any of the panelists have thoughts on two issues. One, if we take Mead seriously and the idea of a step zero inquiry, what does that tell us about not merely major questions, but other sources of imperfect meaning in statutes that are not eligible for Chevron? So for example, internal conflicts in a statute, should those be treated as ambiguities, or does a delegation theory of Chevron take them off the table? And then secondly, if we take this step zero notion seriously, I'm curious if any of the panelists have any thoughts about how we would apply that to Auer, because it seems to me if step zero in Chevron is based on delegation from Congress, I'm not sure how step zero would work in Auer, where it's the agency delegating to itself.
Yeah, I mean, I'm going to agree with something David said earlier about the origin of these deference doctrines is Congress's intent to let the agencies fill in. And if you understand that as the basis of it, then a step zero has to also be tied to something Congress has explicitly said. I want the agency to solve these kind of fill-in-the-gap problems, whether it's large or small, major policy or minor policy things. If Congress has said, I want the agency to help us with their expertise in filling in those gaps, apart from the non-delegation issues that creates, then that ought to be it. And it ought not to be some a court deciding, well, this is too big an issue for there to be delegation, or too small an issue that we can afford delegation. If the source of the authority for those delegations is Congress has said we're going to do that, it ought not to matter how big the policy judgment is or how little the policy judgment is, unless we're going to go really back to a full-throated non-delegation doctrine.
I mean, this is all downstream of non-delegation, and I agree that needs to be looked at and reformed too. But for me, very briefly on step zero, I'll say, I think maybe the best defense of Chevron is that it's useful for filling gaps, right? And step zero takes this seriously, especially the major questions version of step zero, and says, okay, we'll allow Chevron to fill gaps, but not chasms, right? That we're not going to allow Chevron deference for this most consequential set of policies. It's funny, you mentioned Kavanaugh in his Harvard Law Review article where he says the line between ambiguity and unambiguity is not a bright line. Of course, the same can be said for the major questions doctrine, which Kavanaugh seems to be a big fan of, or the major rules doctrine, as he calls it. It's not that these rules the lines aren't bright, but at least there's something there. I think they're still useful. And I think, maybe we'll get to this later, but I think the best thing we can do with Chevron, again, is try to recalibrate it to create the right incentives for the lawmaker. And in the case of step zero, a robust step zero would remind Congress that they're going to have to make some decisions for themselves, or these broad delegations of power will be delegations to judges to decide what the best policy in their view is. They won't say that's what they're doing, But that's what it looked like a lot in the 1970s when it was Skelly Wright and David Bazelon on the DC Circuit. And I think a robust step zero reminds Congress that the judges ultimately will be in charge of deciding these policy issues. And Congress might want to think harder before they write some vague policy aspiration into law.
By the way, you solve that with teeth and an intelligibility principle. I mean, let the court develop a robust jurisprudence on what constitutes an intelligible delegation of power. Has Congress made the basic policy judgment that we expect the legislature to make, or have they passed the buck on that? And if they pass the buck on that, it's invalid. If they've made an intelligible principle about what that policy judgment is, then the agency can apply its expertise to this particular circumstances that meet that policy judgment. But we have no intelligibility principle jurisprudence now that does anything close to that.
Jean?
Yeah, I wanted to follow up on John Eastman's question, specifically ask Professor Vladeck about it because it's intriguing to me. Okay, you have the problem which Congress passes something broad and general and cannot get through what actually ends up getting passed and what they perhaps know will get done by the time it goes through agencies. To what degree does that bother you, and to what degree would some of the things we seem to be becoming a little agreement about in this panel actually address that in practice, or how should it be addressed?
Yeah, so I think John's hypothetical is everyone's sort of nightmare about how Washington can work. I don't think it's an unfair hypothetical because I think in practice it happens probably more than we would all like. But I do think that there are all sorts of controls in the way the judicial review process works and the agency review process works that would make it very difficult for the agency to supply that missing piece of legislative, the piece of legislation and get away with it. There are just too many controls on the administrative process. Earlier my friend Adam talked about how easy it was to do notice and comment rulemaking. Really? Having served 4 years as the head of a part of an agency that was engaged in rulemaking, it's a nightmare. And there are many constraints, and I was in an independent agency, so I didn't have to deal with OIRA. If you start looking at the constraints on the regulatory process, I think the scenario that John talks about, I just don't think it would make it through the regulatory process, and if it did, the DC Circuit or some other court would strike it down. Particularly if there was a record of opposition. If there was a proposal in Congress that someone pushed and it didn't get enacted, regulatory state isn't going to fill that gap.
Making regulations is hard, but living under them isn't exactly easy either. And I think we shouldn't, when I said it's easy to do notice and comment rulemaking, I meant relative to other things, of course. I don't think it's asking too much to agencies to notify the public of the proposal, take comments, respond meaningfully to them, and then suffer some form of judicial review. Quite frankly, compared to the legislative process that rulemaking is increasingly a substitute for, it's a walk in the park.
One final question.
Richard Belzer. I'm not an attorney, I'm an economist, and so I can make all this up. On the one hand, and then I'd like to set up an example for you and see what your answers would be. I have spent quite a bit of time recently dealing with an old statute, the Safe Drinking Water Act of 1974, which Congress established three goals or three directives to EPA. One is to establish very stringent national standards. A second is for these standards to be economically feasible. And the third is for them to accommodate the special needs of small water systems. Now, I'll submit to you that you can choose any one of those, but you can't do all three. You can't even do two of them. How should the courts deal with that, and how should EPA have implemented a law that directed it to do fundamentally incompatible things? And I think Congress knew that it was doing that in 1974 when it enacted that.
Well, there are a lot of statutes passed in 1974 that do exactly that. I mean, the Occupational Safety and Health Act does the same thing. And the courts have, I think, given fair amount of leeway to agencies who are trying to reconcile these mandates that are not, capable of all being fulfilled at the same time. The Flint water crisis is in part a result of that. And so, that's a problem that Congress ought not to put agencies in, but does all the time. And I think the judicial process has been relatively forgiving of agencies that can't simultaneously do all three things.
Since we're talking, go ahead. No, please. I was going to change the subject. I was going to change the subject slightly. Since we talked about Congress, I want to make one point that I think hasn't gone made but needs to be made. We're talking about these doctrines more or less like they're all or nothing. I think it's the wrong way to think about it. I think especially with Congress, to the extent they want to write something into the APA, I think we ought to understand that for exactly the reasons that Roman identified, the agencies really value Chevron deference, right? We should use it as an incentive. We should use it as a carrot to pull them through more procedural hoops, right? The knock-on increasing rulemaking requirements is always it's going to defer rulemaking. Agencies won't go through formal rulemaking. It's too hard and so on. Well, if Congress just crafts the APA in a way that leaves deference for things that go through heightened rulemaking and takes it away from everything else, right? You create the incentive to get the agencies to go through a better rulemaking process up front. So I think the best solution for all of these debates has nothing to do with what the courts might decide, and it's Congress taking Chevron seriously as a means, not an end, and using it towards the end of a better regulatory process and better public administration in general.
Great. Well, I think this panel has definitely illustrated that we have a variety of views on deference doctrines. We managed to reach a little bit of common ground on some potential means of narrowing or, tweaking the doctrines. But I think the debate's going to continue, and it's certainly going to continue as we see what the court does or does not do this term in Kisor. So before I thank our wonderful panel, I've been instructed to announce our next panel is going to be in here at 2 p.m. It's the Civil Rights panel, and there's going to also be a panel in the East Room on environmental issues. So thank you very much to our excellent panel, and please join me in thanking them.
Seriously, I was just sitting up. That was fun. Great job.
Adam, good to see you. John, nice to see you.
Get through the whole thing.
John,
That's good.
very interesting script with a good callback.
Some might say the government will put a meeting in this.
I know.